is Julie. I'm a lawyer and a former top law student and lecturer in communication studies. Today we're going to talk about the tort of Rylands and Fletcher. Rylands and Fletcher is an odd tort, and it's named after the case that it comes from, which is the Rylands and Fletcher case. So it's basically, in a nutshell, when someone has something on their land that is coming into your land. So maybe they've got a huge water tank on their land and it bursts and it spills and floods into your land. So that could come under the tort of Rylands and Fletcher. There are 6 elements to prove Rylands and Fletcher. The first is that someone needs to bring something on to his or her land. The second is that what they've brought onto their land has to be a non-natural use of the land. The third element is that the thing brought onto the land needs to be dangerous or foreseeably dangerous if it escapes onto the neighbour's property. The fourth element is that the thing must escape. The fifth element is that the thing has escaped and it's caused damage to the plaintiff's land. And the sixth element is that the damage needs to be reasonably foreseeable. So Rylands and Fletcher is considered strict liability in that you don't need to prove that the defendant was negligent. You just need to prove the 6 elements of the tort. In relation to element 1, which is bringing something onto your land, the thing cannot naturally occur on the land. So you have to have gone out and brought something non-natural onto the land. For element 2, it needs to be a non-natural use of the land. So you need to bring something onto your land that is very strange and kind of outrageous. So if you own a farm and you have a tractor on your land and somehow it explodes and goes and the debris blows onto your neighbour's land, that probably wouldn't come under the second element because it's pretty natural to have a tractor if you live on a farm. But if you're in a normal suburban property and let's say you have randomly like tons and tons and tons of chemicals stored in your backyard because you're doing some sort of entrepreneurial venture and that explodes and flows onto your neighbour's land and ruins their land, the amount of chemicals you have would probably be considered not a natural use of a normal suburban property. The third element is that the thing must be dangerous. The test for this is that the defendant needs to have done something which, according to the societal standards at the time, has given rise to an exceptionally high risk of danger or mischief occurring. The fourth element is that the thing must escape. So in the case of Ponting and Noakes, a horse leaned over to the neighbour's fence and started eating some poisonous leaves and died. So this was not considered Rylands and Fletcher because the leaves didn't escape the property of the defendant and emanate onto the plaintiff's property. The fifth element is that it must damage the plaintiff's land, so the plaintiff needs to own the land or have some sort of possessory right to the land. The sixth element is that this type of damage must have been foreseeable. So it's quite foreseeable if you have a whole bunch of water stored in a huge tank that if it somehow breaks, it will flood your neighbour's property. That's quite foreseeable. There are a couple of defences to Rylands and Fletcher. So the first one is an act of a stranger. So if someone comes onto your property and forces this thing to escape, you wouldn't be liable for that. The second defense is an act of God. So that means something natural occurring. So if an earthquake starts shaking the ground, causes something to escape your property, you also wouldn't be liable for that. Another defense is statutory authority. So if you're doing something you're legally allowed to do, you'll generally be exempt from being liable under the Rylands and Fletcher tort. Another defense could be consent. So if the neighbour has consented to you having something on your land, it's generally considered they can't later complain under Rylands and Fletcher that you did something wrong. And another defence is the fault of the claimant. So in the Ponting and Noakes case, the claimant was considered a bit negligent that he let his horse lean over the fence and eat the neighbour's grass or poisonous leaves. So that is a defence. That was Rylands and Fletcher in a nutshell. If you want to buy my personal study notes for this subject, please see the description. There's a link to my website where you can buy them, or you can just email me. Thanks for watching and please like and subscribe if you like it, and see you next time. Bye.